My name is Amy Maes. I'm the Director of Access Services for Disability Network Eastern Michigan, and I'm also the statewide coordinator for Access Services for the Disability Network of Michigan, which is a collective of all the Centers for Independent Living. I am an older woman, short stature, blonde hair, and I'm wearing a blue shirt. I have this distinct pleasure of welcoming you to the Responsible AI, Assistive Technologies, and Digital Accessibility Workshop. The session will explore guiding principles for disability-inclusive AI, the Department of Justice ruling related to WCAG 2.1AA, and the Federal Technology Act of 1988, current accessibility gaps and policy recommendations. Before we get started, we have a few housekeeping matters to review. There are ASL interpreters and CART services in this session. If you have any communication issues during the session, please let one of the staff know. Please identify yourself before speaking. And please, if you wish to comment or pose a question, we have note cards on each of the tables to submit these questions, and staff will collect those. If you prefer to comment individually, we will be having a microphone go around the room at that time. This session will last approximately 1 hour and 15 minutes. After the session, please return to the plenary room for the closing remarks and then the reception. And I thank you for attending this session. I would like now to introduce the panel. We have Dana Justice from the Department of Technology Management and Budget, Dr. Sarahelizabeth Baguhn from the American Foundation for the Blind, and Kellie Blackwell with the Bureau of Services for Blind Persons. The full bio for these panelists can be available on the WHOVA app if you want to download that or get the QR at the registration table. Some ground rules for the discussion. Please keep discussions focused on topics, specifically broad policy implications. We would like to end this session with 2 or 3 specific policy recommendations to promote accessibility and inclusion in the digital world. We are unable to address individual complaints and circumstances. There will be time allotted for question and answer at the close of the session. We welcome comments with potential solutions for the issues being discussed. As earlier mentioned, there also are the note cards that will be going around. Inappropriate, inflammatory, or disrespectful behavior or language will not be tolerated. Those in violation of this requirement will be warned once and then asked to leave. Please join me now in giving a warm welcome to Dr. Sarahelizabeth Baguhn. Sarah is the research specialist for the American Foundation for the Blind. She conducts research with AFB to harms, biases, and opportunities presented by artificial intelligence for people who are blind or who have low vision. Today, she'll be discussing the recent AFB study, Empowering or Excluding, the new research and principles for inclusive AI.
Thank you so much. I am Sarahelizabeth Baguhn, and I'm so happy to share with you AFB's recent cross-disciplinary study on artificial intelligence and how that intersects and creates opportunities for people with disability, and also what sorts of policies we might need to look at and consider to prevent harm to our populations. You will find on the tables you're seated at a few copies of our policy guidelines, and they're also available in the WHOVA app. But I want to take a few minutes to talk to you about how we got from wondering about opportunities for technology to provide accessibility solutions to people with disabilities, considerations for how artificial intelligence can support accessibility in the community, to also being concerned about how there are risks for discrimination, privacy violations, and other harms to our population, so that we focus some research on how artificial intelligence needs attention in relation to folks with disabilities. So to get to this point, we did a study with a set of experts in AI policy, disability policy, development of AI, and industry. And we asked a wide group of experts to come together and create consensus around some topics. What were the things that, even with their diverse backgrounds, they could all agree were taking place? And we really wanted to focus this around key domains of our daily lives. So we looked at transportation, education, employment, healthcare, and assistive technology. The goal here was to try and understand what the experts agreed is happening or is about to happen in the AI space in relation to disability, and also to kind of analyze the dissent whenever experts had different opinions and try and understand why they thought there were differences in what they expected to come next. We found many areas where the experts shared consensus. Folks were in agreement that AI can be used to improve wayfinding, directions, turn-by-turn direction kind of things, as well as sidewalk accessibility. Really exciting that big data about where everyone walks can help us identify which sidewalks are broken and need to be fixed so that we can better repair our communities and keep accessibility at the forefront. We also found that blind users in particular may prefer AI for reading private material over a human reader, if we adhere to the caveat that that AI is storing something locally and not sending it up to the cloud to be kept in perpetuity forever. Our experts shared some accessibility concerns. There were worries about AI coming into classrooms before it was fully accessible and creating new accessibility barriers for learners. There were concerns about AI literacy tools that use sort of drag and drop interfaces being inaccessible for all of the non-mouse users in our community, so whether that's blind people or folks with physical disabilities, that new tools teaching folks how to program with AI might not be fully accessible. There were also accessibility concerns around image generation tools. Right now, you can ask an AI to create you a picture of and then describe what you want. If you ask it at the end, what's that a picture of? It's going to base its answer on what you asked for, not on what it generated. So anybody who's blind or low vision doesn't have a reliable way to check what's being generated. There was strong consensus around bias concerns. Our experts were very concerned that AI systems would discriminate against people with disabilities because, by definition, there's some characteristic of them that is not average within the population, and that that's going to have harmful impacts on employment and healthcare access. There's also a concept concern here called automation bias that we all need to be aware of as we do work that checks the AI's accuracy. Humans have a tendency to think that the computer is an impartial decision maker, and so if the computer says, put this person in category A and this person in category B, the automation bias tells us that it's doing that in a fair and rigorous way, the same to everybody. And it's a bias that causes us to overtrust AI. In fact, AI is not a fair decision maker. It is a decision maker that learned from the patterns of human decisions, and our decisions are flawed with our own biases. The AI likes to amplify those biases and do our prejudice even better than we did. So our experts had agreement that they needed oversight and transparency around AI. That means a human should be reviewing AI automated hiring decisions or other sorts of filters to make sure that they are fair and equitable and doing what they're supposed to do. That employers using AI for screening of applicants should disclose to the job applicants that AI is being used. It's impossible for you to ask for an accommodation if you don't know that a system is in place. AI should partner with and not replace human educators. And auditing of AI systems needs to directly account for possible AI biases, anti-disabled biases, in addition to gender and racial biases. Interestingly, the agreements around oversight and transparency were not just from policy experts and disability rights experts, but these were items that were also in consensus with industry experts, people working on developing AI, are saying, yes, we need policies in place and we need human oversight for these tools to be used well. There was also broad consensus on the need for disability community involvement. People with disabilities need to be involved in all aspects of AI development, deployment, and policy making. That means we need disability representation in the tech field, along with all other forms of human representation. We will also need some strong federal and state policies protecting privacy laws for folks with disabilities. A final area of consensus was the need for regulations, that AI regulations need to be written proactively, informed by the disability community, and should aim to specifically protect the rights and privacy of people with disabilities. With all of these consensus items, that gives us good information about how and where we want to write AI policy. There were also areas that the expert panel could not agree with each other on. My favorite is autonomous vehicles. We had some experts convinced that autonomous vehicles would be in a neighborhood near you, offering you private robot self-driving services within the next 5 years. And other experts who insisted, no, there are technological barriers or policy barriers that means the rollout and implementation of this is going to be so much slower. Another area of debate was experts disagreeing on whether AI will increase the productivity and inclusion of workers with disabilities, or if it will exacerbate current gaps in employment and cause more reasons for people with disabilities to remain unemployed. The reality is AI does nothing to address the attitudinal barriers of employers. And so in the cases where people are not getting jobs because folks just don't believe a person with a disability can do that job, AI tools will not change that opinion on their own. With that, we come to the AI guiding principles, which again are available on your table or in the Whova app. And these are a set of principles that are not ready to adopt government regulations or rulemaking, but rather written broadly in a sense that anyone can consider these principles at any intersection where they interact with AI. That could mean that you, as the person adopting AI for your agency or your employer, is aware of it. They could be principles that you use as a person utilizing AI on your job to improve your own writing or efficiency or fluency. Some of the principles that I want to highlight include when AI has a significant impact on people's civil rights, health, safety, freedom, or opportunity, both deployers and developers have an obligation to ensure that the AI models in use are not discriminatory, either intentionally or unintentionally. AI systems should be designed and audited to ensure that they do not amplify harmful stigmas about people with disabilities. Producers of AI training datasets should evaluate whether their datasets represent a sufficiently diverse range of people with disabilities, including diverse disability types and people with intersecting identities, and modify their datasets accordingly. We want AI developers to actively recruit people with disabilities into their workplaces, and AI workplaces should be fully accessible. That includes ensuring that AI programming and training tools are accessible and that there are accessible avenues for people with disabilities to learn AI skills. AI software should fully conform with international accessibility standards, such as the Web Content Accessibility Guidelines 2.2, Level A and AA, sometimes called WCAG. We want the use of AI in software and decision-making tools to be clearly disclosed to all of the people they impact. Impacted people should understand how to request a reasonable accommodation or how to appeal decisions to a human reviewer. We see this in job applications, we see this in healthcare insurance decisions, we see this in benefits eligibility decision-making. If you don't know AI was used, you can't ask a human to look it over. So it's important that all parties know when AI is in use. AI should not entirely replace human educators when delivering instruction or developing educational plans. Students and employees with disabilities should be able to use AI as assistive technology. We had some great discussion this morning about how do you navigate when an employer or a school has a baseline policy that says, no AI ever. Well, what if AI is the most effective assistive technology for you? What if the assistive technology you've always used and you've been trained to use has recently had AI built into it? Are you supposed to stop using this on the job? What's the process there? And how do we work together with employers to ensure that folks can use the best assistive technology for them? When using AI with sensitive or private information, we want to see cases where users are able to choose where the information is stored and who can access it. If I'm going to scan a piece of mail with AI that's going to read the text to me, that piece of mail might be a medical record. It might be my bank account statement. I don't want my bank account number in the cloud where some hacker can get to it, and neither do you. So there's got to be some privacy options built into these assistive technologies. At this point, I want to be sure to thank the Delta Gamma Foundation for funding of this specific project, as well as the Ford Foundation for their generous support of our technology research efforts. And I would invite some audience participation at this point, if a few people would share. Looking at the policy guidelines, either on your table or in the Hoover app, what is one guideline that either you could see your agency implementing, or that you would see being a challenge to your agency, and why would it be hard for you to follow such a guideline? And hopefully some of our mic runners can bring mics around to the tables. Just takes them a minute to read through the stuff. They're figuring it out.
Oh, okay. Hi, my name is Scott. I'm an older Caucasian male, salt and pepper hair. My question is, or my comment, the response is, maybe at our agency, because I'm working with MRS, that maybe they can assist with the documentation that has to be put in our systems of conversations that we're having, maybe an AI assistant, but at the same point, we have to be cautious of sensitive information being out there.
That's a great discussion. So how do you balance that need for privacy with the efficiency that it could help to support your services?
Hi, my name is Laura. I'm a white woman wearing a Canadian tuxedo. My agency, I work for the Anti-Defamation League, and the first bullet point on the packet talks about the increase of assistive technology. We're so focused on creating an AI assistant to help our work be more efficient that I don't think anybody is stopping and pausing to think about things like image description, wayfinding, captioning here and there as in the assistant, but everything else, it's like we're moving so fast to catch up that I don't think people are stopping to consider all kinds of different needs and accommodations, because they're so focused on us getting our work done as quickly as possible.
That's such a tricky moment because, of course, if you're getting a product to market as quickly as possible, you're in one speed rush, and later if you're going to remediate for accessibility, the work is so much larger than if it were built accessible in the first place. And so that total work time might end up being much greater if something's built inaccessible first and then has to be remediated. Any others? Anybody else want to shout one out? Flag down a microphone.
Okay. My name is Terry. And I think one of the things that I'm hearing in a couple of groups and I have concerns with as well goes to your point about creating things in an accessible fashion to begin with. We have a number of groups that are out there creating trainings or professional programs and not keeping accessibility at the forefront. And so how we go about, I mean, like, I know it needs to happen, but I'm not the one that knows how to do it. And so I think that there are pockets of things that are going to be missed.
Absolutely. So well-intentioned, but how do we get to all those little nooks and crannies and make sure people are connected with the resources who know how to design things accessible? That's great. Well, I will wrap up there until we get to the Q&A later. So if you want to pass it on to Kellie.
All right, thank you, Dr. Sarah. And now we turn our attention towards assistive technology. And I want to help me in welcoming our next speaker, Kellie Blackwell. She is currently a rehab counselor with the Bureau of Services for Blind Persons. She also has served as the co-director for Michigan Disability Rights Coalition, where she was leading the assistive technology program. She has a wealth of information to share with us today. She'll be discussing federal assistive technology along with some current accessibility gaps.
Thank you, Amy, for that introduction. And I will just add, I am literally 9 days into my new role at the Bureau of Services for Blind Persons. So I had 4.5 years as the director for the AT program at Michigan Disability Rights Coalition. And so that is where I'm going to focus the discussion today is on assistive technology at the federal level, which is the Assistive Technology Act, and then discuss where assistive technology touches in other areas, for example, in the K-12 arena, as well as perhaps in healthcare and some other areas. With the federal scope of the Assistive Technology Act, each state, as well as a handful of territories, there are 56 programs in total, provide services for individuals with disabilities as well as older adults to experience assistive technology. Before I move any further, if I could just get 1 or 2 folks to share their ideas on when I say assistive technology, what are some things that come to mind?
Braille notes.
Braille note is an example, yes, of a device that would be considered assistive technology, absolutely.
My name's Paul. Optical character recognition.
Yes, optical character recognition can be used as a tool for assistive technology, or OCR. Can be very helpful. If there's any other eager folks, otherwise we can just move into some of the
Voice
content.
to text or text to voice?
Yes, absolutely. Voice to text or text to voice.
This is Harold, driver assistance tools.
So, are you thinking of like hand controls and
Sure. That's
autonomous?
not necessarily autonomous, just
Okay.
simple hand controls.
Okay. Yes, that is a great example. Thank you. I'm not sure if anyone else. Okay. We'll go ahead and move through the material. So as mentioned, the federal level, each...
This is the sign language interpreter, so sorry to interrupt. We do have one more comment about OCR. I saw that word OCR. What does that stand for?
That is optical character recognition. It is a...
What does that mean?
That is a process that takes text material and converts it to an accessible form of media that makes it accessible for individuals with print disabilities.
Oh, okay. I have another comment. I do want to ask, could a deaf individual, say if they were using sign language, would that be different? Could they use that? Something for deaf people?
I am not familiar with individuals who are deaf using optical character recognition. That's not to say that it doesn't happen. I just don't know how that would work with ASL interpretation. Thank you for that question.
Okay, I understand. All right. We do have another question. So I thought that there's a new car that's coming out. I forget how it's spelled, but there's a new car, and it might last for a long time. It might be good, but then I heard that. Hold on one second. Oh, it's like a self-driving car that I could just basically sit back and not have to worry about it. And then it will watch for things in front of them. But I've seen that a lot of autonomous cars don't map those out well. They might still hit individuals. So I think it's best that we drive cars ourselves and we let them, have their own car out there.
So autonomous vehicles are very much not ready for the market, I would say. In some areas, they are working on technologies to make the experience safer for all involved. And I don't want to
practicing.
Yeah, I don't want to speak to that too much. I want to make sure that I hit on what's happening at the federal level more broadly with assistive technology, and then cover some statewide aspects. But yes, autonomous vehicles are definitely a hot topic, so to speak.
Okay, understood. All right.
So with the Assistive Technology Act at the federal level, just a very brief overview of the history. As mentioned in the intro, the first iteration of the act happened in 1988, and it was collectively known as the Tech Act. And it has evolved from there and had some changes and amendments. A new one came out in 1994, and then again in 1998, and then again in 2004. And it was the act in the 90s that you see today in terms of each state as well as each territory having a program that is federally funded. So 2004 was the most recent up until the latest version, which happened in 2022, which is now known as the 21st Century Assistive Technology Act. It has much of the same language, however, with updated components that address things like housing and transportation. In terms of the Michigan Assistive Technology Program, who is the implementing entity for the program, it's a really cool way for individuals with disabilities and older adults to get introduced to assistive technology. I had asked your ideas on what you believe assistive technology to be, and for the AT program, AT is essentially any product, device, system, software that is going to help individuals with disabilities and older adults be able to do the things that they want to do. We also had said that technology often makes things easier for many people. So think of your cell phone or your computer. Those are technologies. When they become assistive technology is when you're using those devices to access things that you wouldn't otherwise have access to. So technology makes things easier. Assistive technology opens up possibilities for people with disabilities. So with the Michigan Assistive Technology Program, just a brief overview, The entire state is served, all 83 counties, and individuals can be introduced to a variety of technologies for all populations, all ages, from things like low vision and blindness technology to outdoor recreation. So we had accessible fishing, hiking, hunting, all of those kinds of things, gardening, things like that. But certainly reeling it back a little bit, that's my fishing reference, haha. Digital access is super important in a lot of areas, and especially for someone like myself who uses screen reading technology, I'm hugely passionate about digital access. So there's a lot of assistive technologies that can help access those digital things in the world that are so prevalent now. So with the program, there's demonstrations, in some instances, short-term loans of devices, and just a variety of other mandated services under the AT Act. And I encourage you all to reach out to the program. The program is at no cost for individuals to participate, and there is no medical documentation or anything like that that is required to participate. No referral is needed. You can self-identify, and the program can assist. And you can get introduced to a variety of technologies. So that's the federal level. And another area is in the K-12 school system. You have IDEA, which is the Individuals with Disabilities Education Act, that essentially states that all students with disabilities have access to the assistive technology that they need to be successful in the classroom. Along with that, you have the Free and Appropriate Public Education, or FAPE, that states that students have access to their public education in the least restrictive way possible. And then you also have components of the section for the 504, which is also in healthcare. So all of these areas introduce assistive technology to folks that may need it. And then just in a couple of other areas, if individuals are on Medicaid, as an example, and qualify for waiver services, assistive technology is available through that system as well. So when we look at all of these systems and all of this legislation that is in place to introduce assistive technology to folks, I would say that some of the barriers are often just the large systems themselves. I used education in the first session, so I'll use it again. When you think of the education system, each school gets funding, and how the school rolls out each of their programs to meet accessibility might look different. So then that process can create a barrier, maybe unintentioned, but still a barrier nevertheless. So looking at ways that we can be more intentional and inclusive on making sure that those systems meet the needs of everyone that they are serving is super important. Looking at the idea of universal design, that is basically creating a space where assistive technology essentially wouldn't be needed in a perfect world, right? Because you could just interact with your environment and not have to worry about the environment being the barrier. And something that is often said in the disability community is that the person with the problem does not exist with the person, but rather the environment in which you interact. So I think it's super important to move beyond thinking of universal design still thinking about that, but also then including ways to introduce assistive technology into those systems. Using healthcare as an example. You might be compliant. I hope you're compliant in the healthcare field with access, physical space maybe, to the building or to the rooms or to the equipment, although that's very well not the case many times. But then how can you introduce assistive technology that's not going to have a huge learning curve for not only the staff and the people using it to be able to use it effectively, but having some of those things available for folks to have available when they visit, just as an example. So those are all just ideas to think of when it comes to assistive technology. Assistive technology does not need to be super high-tech. It certainly can be. I am a huge fan of really low-tech things. For example, bump dots. Some of my favorite pieces of AT. Many things come with flat panel surfaces now. Think of dishwashers, washing machines, ovens, what have you. I get a packet of bump dots for like, I don't know, less than $5, and now I've created an accessible way for me to access some of those everyday household devices. That's just my 2 cents. That's where I'll end it for now and keep it, any questions to the question and answer portion, and I will move it over to Dana.
Thank you, Kelly. And finally, please join me in welcoming Dana Justice. As I said before, she works for the state of Michigan, the Department of Technology Management and Budget, and the Center for Shared Solutions. She's a manager in eMichigan, managing the digital accessibility testing team. Today, she'll be explaining the new Department of Justice rule related to Title II of the ADA. She'll also address what is happening at the state level as they prepare for the WCAG 2.1 AA requirements.
All right, so we are going to start by talking about what is digital accessibility. So you're probably already aware of being here and with our first 2 presenters in this session today, but we're going to stick to the basics and define it. So digital accessibility is when you design and develop digital content, applications, and services to be usable by all people. It is the inclusive practice of removing barriers that prevent interaction with or access to websites, digital tools, and technologies by people with disabilities. People can perceive, understand, navigate, and interact with the web. For this topic, for overcoming barriers to access, first I'm going to define what the disability is that we are trying to code for, and then I'm going to give an example of how we need to ensure that we are developing and designing applications to ensure that we are working with those assistive technologies for each of those disabilities. So for instance, a visual disability could include blindness, low vision, color vision deficiency. To ensure that the system is accessible. Color contrast, variable font size, alt text, screen reader compatibility are all key for those development elements. For physical, that would affect mobility, such as weakness and limitations of muscular control. So when developing, we need to ensure that keyboard access is fully functional without the need for a mouse. For auditory, which ranges from partial hearing loss to deafness, transcripts must be reviewed and revised. Automated voice detection is not 100% accurate. For cognitive load, that could involve challenges with memory, attention, and problem solving, such as dyslexia or ADHD. So you need to ensure that content is understandable at a reading level and appropriate for your audience. For speech, it could include difficulty with speech interactions such as muteness, stuttering, and cluttering. So voice input should not be solely relied upon. You need to provide alternatives in your system to speech interaction. So again, keeping it real basic, you're probably already familiar with this if you're here, but we're going to go ahead and define the Americans with Disabilities Act. So at the state level, we do not have a law that requires our IT systems to be accessible. We enforce the federal law by state policy. So the ADA is a federal law that prohibits discrimination on the basis of disability in employment, state and local government, public accommodations, commercial facilities, transportation, and telecommunications. Title I relates to employment, which requires employers to provide individuals with disabilities equal opportunity and prohibits discrimination. Title II relates to activities of state and local government. Individuals with disabilities must be given equal opportunity to benefit from programs and activities and services. So at the state, we've been looking at this before and after a rule change went through. So in April of 2024, a rule change was made to Title II of the ADA. Prior to that date, Title II of the ADA required that state and local governments make sure that their services, programs, and activities are accessible to people with disabilities. And it applies to all services, programs, or activities of state and local governments, from adoption services to zoning regulation, including services, programs, and activities that state and local governments offer online and through mobile applications. However, the ADA did not contain a specific technical standard at that time. So they said you must be accessible, but they didn't have any sort of regulations to hold us to. So now, after April 24th of 2024, the federal rules set a specific technical standard that state and local government must follow to meet their existing obligations underneath Title II of the ADA for both web and mobile app accessibility. That technical standard is set to the Web Content Accessibility Guidelines, also known as WCAG or WCAG 2.1 Level AA. And all new and existing external websites and applications, including website content and mobile applications, must conform to WCAG 2.1 AA by the compliance date as specified by this law. For public entities with a population of 50,000 or more, the state must achieve full compliance by April 24th of 2026. So when this was set, we had 2 years to come into full compliance, and we're about a year out from that compliance date now. For public entities with a population of less than 50,000, they have until April 26th of 2027. So they were given 3 years at the beginning. They are now down to about 2 years. What all is in scope of this rule change? So external systems and content used to provide a program, service, or activity of a public entity. It can include, but does not limit it to, web and mobile applications, systems that were developed in-house, and systems that are procured, such as from a vendor, new systems that are brand new or existing systems, including older systems, systems that are hosted on-premise or hosted externally, COTS, which stands for Customizable Off-the-Shelf, SaaS, which stands for Software as a Service and Subscription-Based, content on websites, conventional documents such as PDFs, word processing and spreadsheets, and social media. So pretty much all IT systems, as well as the content on those systems. There are some exceptions to this federal law. Those are pre-existing social media posts, which must be made prior to the date of the state or local government was made to comply with that rule change. Pre-existing electronic documents, which must be word processing, presentation, PDF, or spreadsheet files that were created before the date that the entity must comply. Archived web content, which must be content created before the entity must comply, and only used for reference and in a special area for archived information. Individualized password-protected documents, so those would be documents that are for a specific individual in a word processing, presentation, PDF, or spreadsheet format, and password-protected or otherwise secured. An example of that would be an invoice that is meant for a specific person. And then the last item is content posted by an independent third party, whereas the third party is not posting due to contractual or licensing or another arrangement with a public entity. So now that we've talked about the laws that apply and impact state and local government entities, we're going to talk about what the state of Michigan is doing to work on this initiative. So our efforts started long ago. I'm going to talk mainly about efforts that are ongoing now, but know that we've been working on this for at least 15 years and
definitely prior to my time with the state. So collaboration is one of the biggest areas where we've benefited from as we've been working on this initiative. So we've had subject matter experts across various state agencies such as Civil Rights, Office of State Employer, DNR, MDHHS, DTMB, all working together to influence on public policy, to help us refine process and ensure that we are pushing our applications to compliance. The department lead work groups as well that discuss accessibility topics and share resources out to their staff. So for example, the Department of Natural Resources has the A team, which has been in place since the 1990s. We've also been working on outreach, communicating with other states and public entities. I believe that one of our members sits on a work group that includes the state of Colorado, the state of Maryland, and the state of Maine, and a few other states as well that we regularly connect with to see what they're doing on these efforts and see if we can share ideas that can help each other along. Additionally, we gain a lot of unique insights and shared experiences from that outreach effort. So policies, standards, and procedures, as mentioned, as a state, we do not have laws that enforce WCAG 2.1 level AA. We have policy, so one of which would be 1650 for accessibility and reasonable accommodations and modification. This is an ad guide policy, and it is enforced by procedure 1650-02 for accessibility and reasonable modifications for ADA Title II. So that one gets into talking about what we must do as state employees to create accessible content. Additionally, we have the State of Michigan Digital Accessibility Standard, which can be found on michigan.gov/standards. It states, the State of Michigan has adopted WCAG 2.1 level AA as our standard for digital accessibility. All SOM digital content shall at minimum conform to WCAG 2.1 level AA. And then for applications, we have the State of Michigan Digital Standards for Websites and Applications, which has an accessibility requirement, a requirement to test applications for accessibility, as well as a few other technical requirements and branding requirements. As a part of moving to this new requirement, so for the prior to last year when we adopted WCAG 2.1 level AA in May, we were already requiring 2.0 level AA, so by policy we had required that for at least 10 years prior to May of last year. So now our current lift for contracts is to make sure our terms and conditions in our existing and our new contract language reference the correct version of WCAG or reference WCAG at all. So we are revising those existing contracts and identifying where updates may need to be made. Some months back, we did send a notice to vendors to let them know that we had adopted a new version of WCAG as our technical standard and asked for some information from them to assess where they were currently at on their level of compliance and their willingness to come into compliance if they were not currently at the level that we required by policy. Also by policy, we require an application review. So this one's the closest to my position here because my team actually conducts these reviews. So by policy, we require all State of Michigan applications and websites are reviewed prior to going into production and that all accessibility issues are remediated before that system goes live. We did realize that we have a lot of systems we've tested against WCAG 2.0. So it was determined that we're going to go back and test all of our external systems to catch any gaps and test all systems against WCAG 2.1 level AA. We refined our process for intaking requests and tracking our progress, as well as we vastly expanded our team from 2 testers to 10 testers in order to accommodate for this influx of work that we saw coming at us. We identified and prioritized systems to test using a risk-based approach, focusing on the number of external users as well as the last known WCAG review status. So on this slide, I'm going to describe how we kind of broke down the priority levels. We have a system where we have metadata about State of Michigan executive branch applications. And from looking at that data, we took a risk-based approach and we established a threshold at 10,000 or more external users with a WCAG review status last known of either issues having been found or the system not having been reviewed at all. And we grouped all of those into a priority 1 group to review first. We have completed the initial rounds of reviews for those applications. The next group down was 0 to 10,000 users with that same WCAG review status of either issues found in the last review or not reviewed at all. And that is our current bundle that we are working on our initial rounds of reviews for. And then priority 3 is where there were no issues found in their last review. That could have been at the 2.0 level or the 2.1 level, but we still want to go back and take a look in case any enhancements were put in place that slipped through the cracks that we hadn't tested yet. And that's at any number of external users. So by taking this risk-based approach, we're hoping that we can hopefully resolve issues for the majority of those impacted, for the higher level of those impacted. So, as I said, we review all of our applications. We then send our report findings to the application support teams, at which time they review those issues, if there are any issues found, and they determine what steps need to be taken to fix those issues. They might need to engage a vendor and have a vendor work it into their process for remediating the issue, or if it's an in-house developed system, they might be able to begin their remediation right away and potentially push fixes in their next sprint. After they work on those fixes, they come back to us for retesting, and their request stays open until no issues are found in their applications. So it's an iterative process where my team will review until there are no issues found. Additionally, at the state, we have several resources available. So for all employees, we have a digital information accessibility coordinator. That is DIAC. His name's John Nestle. You may or may not have seen him around today. He has the joy of having 2 bosses, one in DTMB and one in Department of Civil Rights. So he is a great resource for all state employees and provides all sorts of help and training to everyone. He also maintains an intranet site called Digital Experience, where there's an accessibility page with guides and resources on how to create accessible content. He's also actually in the process through Department of Civil Rights on developing training for all state employees on how to create accessible content, as well as a few specific modules on how to create specific document types accessibly. We're hoping to have that, I'm not quite sure on timeline, but soon. For developers, we have digital guidelines, which is a design framework. And if you are an application developer that has a clean slate and you're developing something for the state of Michigan, you can use components and code directly from that design framework, and it is built to be inherently accessible. If you are a third party and you have a different product you're trying to integrate it into, it's still a great resource to figure out some basic development elements of how to code accessibly. Additionally, for application developers in-house at DTMB, we are working on ensuring they have all the right tools that they need. Currently working on getting them some additional testing tools and making sure that there are screen readers in all the different development shops so that they can do their own testing before it comes to my team for testing. And I believe at this point it's back to Amy.
Thank you, Dana. Okay, and now we're going to transition into the question and answer session. And this is where you have an opportunity to have digested all the thought-provoking points and research findings and what the state level is doing. And so we'd like to hear from you. Again, we're looking to get 2 or 3 policy statements that can make their way up and have an impact on the digital world in Michigan and how we can make it more accessible and more inclusive. So as we wait for more folks to have questions, I will pose a couple of my own. Dana, let me just ask you about AI overlays.
Accessibility overlays. So this is Dana. So we had a question in an earlier session. So there is something called an accessibility overlay that third parties will market as a fix for accessibility issues on your website. So they will sell you this product, and it is kind of like a Band-Aid. You just put it on top of an application you already have existing. However, it has been known in the industry for quite some time that that does not provide equal access. access, that in fact it tends to cause more issues with trying to understand how that system works. Kellie or Sarahelizabeth, did you want to expand on that?
This is Kellie, and I will say in my own personal use with a screen reader and overlays, please no. Overlays are not great, and as Dana mentioned, they can often create more issues with access than if the digital content was created accessibly from the start.
And I did have one more follow-up. It is something at the state level that we do intend to put in our next version of our policy for the state of Michigan digital standards for websites and applications, that you are not permitted to use accessibility overlays on state of Michigan systems.
Hello, everyone. My name is Bridget Heyman, and I have a question for Dana. I am curious of the testing that you're doing on the various sites and things that you work on. How many of your testers are people with disabilities?
One. One that I am aware of. I do not require my team to disclose their disabilities.
Yeah, absolutely, and understandably. I think from a policy perspective, it would be really interesting to look at hiring more people with disabilities to do the work.
We've got a question here from the audience. So I have a question. I want to know more from Dana specifically. You had a part in your presentation talking about priority and how you consider those priorities and the numbers of groups, but I wonder, do you consider deaf people in those groups, or is it just hearing individuals?
This is Dana. We did ask that if any system owners were aware that they had a community that used their system that had a higher number of users who have known disabilities, to come forward and escalate their requests so that we could prioritize those and review those sooner.
Oh, okay.
We do have a written question here from the audience. And this is kind of for all the panel members, if anyone has this specific answer. Are there enough web designers who can design for accessibility? And if not, how can we build a pipeline for this type of job?
This is Sarahelizabeth Baguhn from American Foundation for the Blind, and I will chime in that one strategy that AFB has leveraged to try and fill that gap is to run accessibility boot camps that are intended for general web design or computer technology students, not necessarily those who are themselves blind, but to better understand the needs of our community and how to build accessible websites that are WCAG compliant. So one opportunity is to provide education that fills this gap, because the amount of education web designers get in a typical university program related to accessibility is a teeny tiny mention. It is not a full, robust coursework in how to do the doing. And so agencies stepping in and providing that web design training is one possible solution.
All right, this is Amy, and I have another question from the audience. AI often filters out persons with disabilities through application and the interview process, as you had mentioned. How do we ensure this is resolved?
This is Sarahelizabeth. I would say the resolutions we have right now include putting a human in the loop, and that's a human trained in the cultural competency to check for bias specifically and be watching out for and remediating those biases where they occur.
We have a question over here. So I want to ask specifically, Amy, have you heard of the Helen, or really anybody, have you heard of the Helen Keller Institute in New York? It's not like the one in Michigan. I would love to have one for people here in Michigan.
This is Sarahelizabeth. We certainly collaborate closely with the Helen Keller Institute. Excellent resource for folks who are deafblind and have multiple impairments, and to be able to develop curriculum and resources and assistive technologies that serve that specialty population.
Oh, wow, okay. And we have another comment at this table. I'm sure that work, there's a lot of it, and it's probably really good work you're doing over there.
Hi, this is Bridget Heyman speaking. I've been giving a lot of thought to the regulation or lack thereof around digital accessibility. And so it's good to see things getting more specific and measurable. At the same time, do you see a risk in them getting too specific so that as technology advances, we can't keep up? Would you say that maybe there is a benefit to keeping something like Title II a little more abstract to talk about all communications so that it, factors in everyone and future needs and future technologies?
This is Dana. So I can speak a little bit to some of the difficulties we've had in Title II as the rule change is written, because we're struggling a little bit with some gray areas and understanding how in the IT world we're supposed to interpret those gray areas. So I know for us, for IT, we're very, we want black and white. We want to know exactly how we can meet that need. We need a roadmap. But I do also at the same time see how there would definitely be value in leaving it a bit more open to ensure that future technologies are taken into consideration when law is written.
Seeing no more questions, I'll give chance for more questions to percolate. I'd like to ask Kellie. So I know many folks have, and certainly I've heard stories of people who've waited months, maybe even years for AT approval. What policy reforms do you think are needed to reduce these delays and the process become more person-centered?
Having to wait for access is something, unfortunately, that any one of us in the disability community has experienced on any given level at any given time, really. In terms of policy shift, I think it's super important to, and just as it was mentioned, to have disability testers. I think it's important no matter what table you are at, you need to have people with disabilities at those tables, because that is how policy is going to be shaped in a way that promotes disability inclusion. And gosh, can you repeat the question again? Because
If you're aware of any policy reforms as relate to the delay in sometimes getting the assistive technology that's needed.
Yeah, so I think, again, it goes to that bigger systems issue. Company A or organization A might think that company B has handled the situation, so I think there's a miscommunication between those bigger systems. I also think it's a great opportunity for conversations to happen between disability partner organizations, and also for those conversations to include the individual that is impacted. And as a side, not as a permanent fix, the assistive technology program that is statewide can often help in those situations where someone is waiting for their assistive technology to be approved. Many of the devices that are available through the program are available for short-term loan. So that's not necessarily a fix, but it's a temporary solution. And when you're thinking of access needs, that can be huge for individuals.
Thank you, Kelly. And Dana, you may or may not know this, but it's worth asking. Do you know of or see any state-level support or funding for smaller municipalities that may lack the technical expertise or resources to meet these needs?
This is Dana. So at this time, I do not. There are several free resources that are available out there. However, we're still trying to work on funding at a state level, so I'm not too familiar with what is available at the local entities right now.
And Sarah, you mentioned transparency when it comes to artificial intelligence, and I really just want you to give a little more emphasis on the role that transparency plays.
Sure. Right now, we're seeing lots of companies, agencies, and organizations adopt AI to make their own workflows more efficient, more effective, and often that's done without any kind of disclosure. If the company is using AI to screen applicant resumes, but not telling the applicants their resumes will be screened by AI, then no person with a disability can request a reasonable accommodation to have a human reviewer so that the biases of AI against people with disabilities don't unduly affect them, because they don't know it's happening, so they can't ask for that reasonable accommodation. Similarly, if an employer is using a workforce surveillance AI tool and they haven't disclosed that to their employees, again, people with disabilities are put into this situation where they might need an accommodation and they don't know to ask for it because they don't know the tool is being used on them or on their data. Healthcare denials, benefit systems denials are also sometimes AI leveraged decisions, and people need to know that they're allowed to appeal those to a human reviewer, and how. What is the process? Do you send a written letter? Do you call a place? Do you fill out a web form? So we need clarity around the use of AI so that people can make informed decisions and have some agency and some personal choice in how they interact there.
Yeah, I think that's a pretty weaved through policy discussion when it comes to policies around that very transparency, right? If you're using AI, make sure your consumers, your students, whoever it is, are aware that that's being used. I think we have some questions.
I'm sorry, maybe this is more not common knowledge that I'm aware of. Can you give an example of how AI might misinterpret a resume or an application for a position? I only ask this because sometimes, you know, like when people are like, well, what do you want in your IEP? And you're like, what are my options?
Yeah.
Or like, what is it I'm looking for? So just out of my own curiosity, I'm just wondering what that might look like. Thank you.
Yeah, this is Sarahelizabeth. Some identified points of resume discrimination include a gap in employment history that aligns with acquisition of a disability, right? So somebody goes blind, they go to a year of blindness rehabilitation to learn the skills to do a job blind, and then from then on, every resume screener system says, there's an unexplained employment gap. I bet that person got fired for cause. We're gonna move them down the stack. And it's not that they got fired for cause. It's not that they did anything wrong. It's that that was the acquisition of their disability, or that was the rehab for their disability that interfered. And that's a common flag. The other kind of parity with resume systems is applicant testing systems. So you play a little game on the computer or you take a quiz and it's tracking how quickly you respond, how your focus is. Well, if that system is using eye gaze and AI to track how my eye movements reflect my thinking skills or my attention skills, guess what? My blind eyes don't move like a sighted person's eyes, right? And so I'm gonna score lower on some of those applicant tracking tests as well due to my disability.
Yes, hello. I'm Heather Zielinski. I'm with the Autism Society of Greater Detroit. Specifically in regards to AI, I know that Facebook and other applications like that have used AI services to help take down false information and provide a better service. One of the situations we were up against as a nonprofit is that their AI system inadvertently took down our page. That's twofold. One being that as nonprofits, we serve a lot of individuals with disabilities across the state and across the country. That access is important to us to provide our service. There's also nobody that we can reach in those situations to specifically dispute the decisions of AI. When we talk about policy, I would like to request that if AI is being utilized in situations like that, I'm not opposed to it, but there should be a clear decision maker that we can reach out to and a clear appeal process so that we can make those decisions in a timely manner and have it corrected.
Hi, my name is Dessa. One of the things I'm thinking about in this conversation is about how if you need accommodations and there is an automated system where you can never talk to a human being, you can never actually make the request. So I don't know if this is a policy solution, but can there be something that says if you have an automated system on the phone or you have an automated chat bot on a website, you should always have the ability to talk to an actual human being in some way. I recently encountered this when trying to rent a car with hand controls, and guess what? I showed up, and there was no hand controls on the car that I had paid for. And it's because I could not talk to a human being after like hours and hours of trying.
All right, I think we are at the end of the session. I want to thank all of you for the questions and responses and the feedback that you offered us. Like I said, we are going to be looking at bringing some actionable policies, recommendations up the ladder. And I think now we get a little bit of a break, and then we're going to be entering into the closing plenary, followed by the reception. And again, I want to thank everyone for joining us today. And if you're not going to take or use the handout, please leave it on the table, and we're going to reuse, recycle. Thank you.